All right. Well, it is a summer afternoon. We don't want to keep you too long today, but we do have an exciting and I think interesting presentation. Welcome, everybody, to our July webinar. Uh, we get so many questions from clients about estate matters throughout the year. I think most people are familiar with the importance of having a will. But often there is a little bit more confusion about having a power of attorney document, what types there are, why would you need one? And so we thought it would be a great opportunity to bring in a guest speaker, a lawyer that we've done some work with named Shawlee from Harper Grey, to help essentially explain what power of attorneys are and how they work. For those of you who don't know us, maybe guests joining us today, my name is Lorenzo Pedrozzani. I'm a portfolio manager with Westmount Wealth Group, and with me is also Matthew Evans, who is the other portfolio manager on the team. As always, a quick disclaimer. Today's presentation was prepared by Rose at Harper Grey and is not endorsed in any way by IA Private Wealth or Westmount, and the opinions held herein obviously do not reflect on our parent company. So with that fun out of the way, and without further ado, Rose, welcome to today's webinar. We're super excited to have you with us. Please do a quick introduction on kind of who you are and what your specialty is in the law, and let's get into power of attorneys.
Thanks, Lorenzo. Lorenzo and Matt, I appreciate you hosting this event. There's so much confusion around these, and my deepest fear as a practitioner is that people will turn to Google for the answer because you get information from all jurisdictions. So I practice exclusively in the area of what we call estate and wealth advisory, which only lawyers would come up with because it's a euphemism that tells you absolutely nothing about what we do. That basically means estate planning, and that covers things from your really simple estate planning like wills and powers of attorney to more detailed planning like tax-driven business reorganizations and trusts. One of the key things about estate planning is that it's really up to each of us to control how we want our affairs managed, and that really appeals to my inner control freak. So the purpose of today is to give you a sense of control out of a very messy topic. Just as Lorenzo mentioned earlier, unfortunately, it comes with a big fat disclaimer. Everybody's circumstances are different, and how this information will apply to you and to your circumstances is, of course, subject to a full canvassing of your facts and your needs. So these are general principles only. Our agenda for today is really going to focus on the basics. What the heck is a power of attorney? You'll have heard lots of variations of the term, so we're going to try and shed some light on that. And a key component of understanding what a power of attorney is actually boils down to what a power of attorney is not. So we're going to talk about the power of attorney as opposed to representation agreements and joint assets. And then just for the sake of something new and different for a lawyer, we're going to give you some practical information as well. So our first topic here is, what is this beautiful tool called a power of attorney? The one you tend to hear most often about is called an enduring power of attorney. Each province has its own rules and respective powers of attorney. So what you hear in BC may not necessarily operate in Ontario or PEI, etc. In BC, the concept is restricted to financial affairs, and that's a defined term in the legislation itself. And this basically captures day-to-day banking, buying and selling your real estate, making investment decisions, filing your tax returns. If you have private company shares, voting those shares. Those, of course, would be subject to terms under any shareholders agreement, but it's just the day-to-day overall management of your legal and financial matters. When we talk about an enduring power of attorney, this is what most of us want. There's a bizarre setup in the legislation where, unless you expressly say otherwise, if I lose my marbles, my power of attorney is useless. It becomes invalid if I become incapable. Since most of us create these documents for the purpose of handling our affairs if we become incapable, it's really counterintuitive. So when you make an enduring power of attorney, what you're actually saying in the document is that it endures beyond my mental incapability. When you're working with a power of attorney of any kind, it's really important to consider what powers you want to be in there. And this is particularly the case in enduring powers of attorney, because they're likely going to be used for an indefinite period. I may never need my power of attorney. I might have made it, put it on a shelf, and died peacefully in my sleep, fully capable. On the other end of the spectrum, I could have been incapable for 15 or 20 years, and somebody's been having to make all these decisions for me during that window. In the absence of a crystal ball, we don't know how long that is, and we want to make sure that when we create a power of attorney, there's the scope of powers you need to manage things. The first one that often gets overlooked is how to deal with gifts and the use of property. The default position under BC's Power of Attorney Act is that there's an annual cap on the gifts that my attorney can make using that document. And there's a percentage or a dollar amount, but the general takeaway is that the total maximum that can ever be done in a year is $5,000. Now, in theory, this is really nice because it protects me from my attorney just giving away my stuff to anybody under the sun. But what about the practical situation where I become incapable and I'm still financially supporting my kids? Or I'm a blended family, and the way things are set up is that my spouse and I regularly contribute to a joint account or pay certain of our expenses. All of a sudden, those would have to stop if the total for the year exceeds $5,000. So you really have to think about how this works for your circumstances and build in the powers to make it function for your life. This has a direct connection with the power to use assets. Just like my attorney has a starting point of not being able to give my assets away, they're also not allowed to let people use my assets for free or at less than market rate. So a really common scenario is one or more of my kids is living in property that I own, and they're either paying absolutely nothing because I'm the world's most generous parent, or they're paying fractional rate. They'll cover the utilities or something like that. Again, this becomes a problem if you just have a standard form power of attorney. If I were to become incapable, that couldn't continue without breaching those duties. So it's really important to factor this into your circumstances.
So Royce, can I interrupt your flow for a second here? Who needs a power of attorney? If who would be, give me a few examples. What's that?
Every human over 19.
So even if I am not married and no children, you would still suggest, that I have a power of attorney.
It actually makes it even more important. We're going to come to what happens if you don't have one at all a little bit later. But one of the things that's really important to keep in mind is that this is all about having an opportunity to set a structure where you can choose who will manage your key affairs if you're not capable. If you don't choose to exercise that, you're basically leaving it to the government or the court system to decide that for you. Not ideal. And if you don't have immediate next of kin, or just as problematically, you don't like your next of kin, it happens. Then you're in a position where somebody who doesn't reflect your values, who may be lousy at financial management or record keeping, is going to be appointed by the court to handle those for you. So everyone over 19 in BC should have one. No ifs, ands, or buts. Now, while I say that with absolute gusto, it comes from a place of equal hypocrisy because I haven't done mine yet. So do as I say, ladies and gentlemen, not as I do. The other thing that's really important about these is how you factor in the power to deal with businesses and borrowing. When you've got any kind of borrowing that has to be undertaken, you have to factor in that a lot of us borrow not just for our own benefit, but we may be borrowing for our companies, or we may be acting as a guarantor for a company, or acting as a guarantor for our kids' mortgages. All of this has to be allowed. And if you have business interests, whether they're companies or partnerships or joint ventures, you want to have the agility to restructure these as needed. Because unfortunately, the only thing I can promise you is no matter how perfect and how well thought out your planning is, the tax rules will change. So you want to make sure that that can evolve with you. But what happens if you have a springing power of attorney? And what the heck is that? So you've made an enduring power of attorney. It's going to be valid until you pass away or until you choose to cancel it. It's not going to end when you become incapable. But when you create a springing power of attorney, it delays when that document starts. It says it's not triggered until you become incapable. There's the illusion of comfort that comes with this. And as you can probably tell from my slightly snide choice of words, I hate these. When you have a springing power of attorney, it means that within the four corners of the document, there's actually provision in there that says this document isn't valid until. And usually the until is very specifically spelled out, and it has terms that often say until one or more doctors, sometimes two or three, provide a statutory declaration saying that I'm nuts. Well, in theory, that sounds really great. Nobody's going to do something they shouldn't. But what happens when you can't get a doctor to swear those? I just had a file like this at the end of last year, and it cost us an insane amount of money to get things done in time. We're talking upward of $10,000. It involved court applications. We had doctors who weren't comfortable providing this. And it wasn't because incapacity wasn't questioned. It's simply because the moment you put a requirement in there that people have to swear something, they run it up the flagpole with their insurance companies, they run it up the flagpole with their internal regulatory bodies. You're just in a different landscape, and people are inherently more reticent. The alternative to this, that in my experience gets the job done far more elegantly, is allow your lawyer to store your document for you. Most lawyers will provide this option, and they don't charge you anything for it. And then they will accept the storage of that document on the express term that they will not release it unless you instruct its release at the time. So let's say you're starting to develop early signs of dementia or Alzheimer's, you contact the lawyer and say, I've got this, I'm still capable, but I know where this is trending. I want, if my attorney asks for it, for you to release this document. Or if just a straight medical letter is provided by a doctor to the law firm. So it provides you protection without creating these hurdles that can, but based on what I've seen, completely negate the practical value of the document.
So Rose, sorry.
Go ahead, Matt, go ahead.
Just to clarify that, you're suggesting that an individual has an enduring power of attorney held at the law office, and you're just creating this sort of
you're creating a fence that has to be opened before it's released.
Correct. Okay. Just wanted clarification on that.
That's brilliant. I love the way you put it. Thanks, Matt.
Okay.
Are there any conditions under which you might recommend a springing power of attorney?
I haven't come across one yet.
Okay.
The legislation changed in BC in 2011 that made it absolutely clear that springing powers of attorney are in fact legitimate in BC. Every single one I've come across so far has been problematic in implementing. So I'll never say never, because there's going to be the possibility that one perfect circumstance comes around. It hasn't made its way to my desk yet. I treat them with great caution.
Okay.
The counterpoint to all of these other powers of attorney is the limited power of attorney. So an enduring power of attorney runs until you cancel it or until you pass away, and it starts from the moment you sign the document. A springing power of attorney runs for the same period at same end date, but it doesn't start until you have a triggering event, usually medical declarations. What a limited power of attorney does is it deals with a really specific time or a really specific set of powers. So the example I like to use is I was out of the country way back before the internet and all that jazz, and I needed to close on a piece of property. So bless my mother's heart, I gave her a limited power of attorney and she bought the property for me. So it had a limited period and it was specific to dealing with that property. It can also be used for other purposes, and this is really common where clients are either part of a blended family or where they have business interests. So let's say I'm a Liz Taylor type situation and I'm on spouse number 6 or 7. I don't want to limit my options here. And perhaps not surprisingly, spouse number 7 is not really on great terms with everybody else in my child group from those past relationships. And I know that if I appoint my spouse, there's going to be a lot of tension and problems in the family when decisions are made about my finances. So I can actually separate out who has powers over which assets. So for example, if my spouse and I own real estate together, I can give my spouse power of attorney over my real estate, but not necessarily over other assets that are intended to pass to my kids. When you're dealing with business management, it also comes up a lot simply because often businesses require certain specific expertise. And you may want to appoint your business partner or something like that to deal with the ability to vote your shares, but not over your day-to-day finances. So when you're dealing with powers of attorney, you can separate out which bundles of rights you give to different people. These are often also still enduring. So if we look at the example where I gave my mom the power of attorney to buy my house, it only needed to be in place for a little bit of time. But if we're looking at something where I'm separating my business management from the rest of my assets, I still need both of those to carry on if I lose my mind. So when we have limited powers of attorney, it doesn't mean that they can't be enduring. They can also be springing. So really what you're doing is you're taking any other kind of power of attorney and you're just narrowing down what it applies to a bit. One of the things that's super dangerous, though, is if anybody listening today has put powers of attorney on their bank accounts, be careful. There's often a form you can sign that says, Joe Smith is my power of attorney for this bank account. The problem this creates is that the legislation itself says that all of my attorneys whose powers cover the same concept have to act unanimously on things. So the problem you get into really easily is, let's say I create a power of attorney and I appoint Matt under my general enduring power of attorney. But on a particular bank account, I've appointed Lorenzo. They may not know about each other. And as far as the bank is concerned, they may be willing to take instruction from Lorenzo because his name appears on that bank account. But in reality, under the law, both Lorenzo and Matt have to act jointly on every single decision affecting that account. So when I have those, it's really easy for my attorneys to end up acting offside. Now, what happens if you don't have one? Bad things, all kinds of bad things. So I don't generally like the government making a lot of decisions about how my affairs are run. I'm a bit of a skeptic, and it doesn't matter which level of government you look at, none of them seem to be able to balance a budget. So giving them control over my finances makes me a little uneasy. But if I don't have a power of attorney and someone has to make my financial decisions, they go to court and they get what's called a committeeship order, which is basically a court-appointed power of attorney. Here's the problem. Anybody can apply for that. There's a hierarchy of the people who can apply and in what order, but they can also object to each other's appointment. And there's a provincial body called the public guardian and trustee who has to approve whoever is going to be appointed. So you've got a lot of intervening factors that can lead to somebody you might not want having make these decisions ultimately have final say, with the government playing an active role in who's going to be approved. So you've got no control about who's going to do it, but you also don't have control about the scope of decisions. So when we were talking about the enduring power of attorney at the front end, I mentioned about how gifting and using assets and business restructuring are not basic powers. When you get a committeeship order, typically it doesn't allow for these things. So if you need those powers and you've got a committeeship order, you often have to go back to court yet again to have those activities blessed, which means yet more money. So by the time you get through a committeeship process, if you've got a complicated family dynamic or complicated business structure, you could spend tens or $20,000 on this without blinking an eye. So it's really, really important to manage this while you can mitigate your costs and control what powers you want people to have and who should have them.
So unlike a beneficiary designation at, let's say, an investment account level versus a beneficiary designation in the will, whereby, from my understanding, in general, the will would override the beneficiary designation done at, so let's say, your TFSA or your RSP account level. In a POA situation, an account level designation is not overridden by an enduring power of attorney.
No, it creates an obligation for all attorneys who have the same turf to act unanimously. And it's really common that people act in violation of that because they just don't know.
Okay.
One of the things that's not within the scope of powers of attorney is healthcare, and that's where representation agreements come to play. So here's just a little doodle so you get a sense of which documents operate when. If you do an enduring power of attorney, and it's not a springing one or it's not a limited one, it's valid document from the time you sign it, and it typically ends on your passing. Usually the person you name as attorney can't can't use it until they sign it. So it's quite common that a lot of law firms will say, you sign it creating it now, but the person who's going to use the document won't sign it until they need to use it because it's another safeguard you can put in place. When you pass away, will kicks in. But in between there, what happens if I'm incapable and someone has to make health and personal care decisions? That's not the power of attorney. That's where the representation agreement comes into play. And some of you are probably wondering if I'm nuts. Answer is yes, but this is still right. It used to be that your power of attorney in BC covered healthcare as well. And in 2001, that shifted completely. So if you recall having used a power of attorney for everything, you're absolutely right. They've just done a big switch on us.
We also hear the word living will thrown around a lot these days. I understand that that's not really technically a thing. Could you elaborate on that?
Yeah, it's almost as useful as writing something out on a cocktail napkin. And BC just likes to be special. Most other provinces have two kinds of power of attorney. You've got a power of attorney for property and a power of attorney for what they call healthcare. BC doesn't do that. You've got a power of attorney for your financial matters and then the representation agreement for your healthcare. In between is this concept of a living will, and it's kind of been hijacked from things like movies and TV, and it's a very American concept. It has zero legal force or effect.
So as a follow-up to that question, sorry, can you explain the difference between an advance directive or medical directive and a representation agreement?
Advance directives are dangerous and should be used in very limited circumstances. A representation agreement appoints someone to handle your health and personal care decisions if you are unable to make those decisions, which means that the scope of what they can decide covers whatever may arise and also gives them the ability to make decisions reflective of changes both in the wishes you have expressed over time and the evolution of the healthcare system. So a really good example is I love to pick on my grandmother. She got very devoutly Jewish as she got older. And in the early 80s, she was starting to have some heart problems. And at the time, the only way they could deal with those was with a replacement that was made from tiny little pig parts. And my slightly fanatical, very devout Jewish mother said, "Over my dead body." Now, if she had made an advance directive, the advance directive would say, "You shall not do this," or "You may do this." It doesn't allow anyone to exercise discretion or make decisions. It just says what's going to happen. Now, about 1986, technology had evolved and they had fancy little plastic ones. She got a new part. She was a happy camper. She was good to boogie. If her advance directive had been in place, she'd have been dead in 86 because it said no replacements, full stop. So it's about the scope of decision-making ability and the agility that comes with it. The other problem with advance directives is that because they don't appoint someone to advocate for you, if you're not receiving the quality of care you need, and this is more common in a long-term care situation than necessarily in an end-of-life decision, there's really no one who has authority to go to bat for you unless they get a court order. So having someone who can be your voice, kick up a stink if they need to, and just generally make decisions that will evolve as medical science does is really valuable. So what happens if you've made all of your assets joint with your spouse? Can you get out of doing a power of attorney? Short answer is absolutely not. They deal with completely different scopes of powers, and it's really misleading because when we're talking about joint assets with spouses, if one of the spouses dies, the other will receive it by right of survivorship. They don't go through probate most of the time. They don't pay probate fees. It's done. It's tidy. And it gives you the illusion that that asset can be dealt with by either of you at any time. It's fun. And it's really important to know how completely dangerous it is to assume that joint is going to get you where you need to be. If I make my asset joint with a spouse and I need to sell my house, unless my spouse has my signature, he still can't sell it. Land title office will not accept it. You're back into that territory of having to get a court order called the comitationship order to have my spouse vested with the authority to sign documents. Just as importantly, if I'm looking at making assets joint with other people so that they can manage my affairs, let's say I want to put my 2 kids on all my bank accounts and I think, oh, this will be great. They'll be able to access everything, pay my bills, no problem. When I create a power of attorney, the person who's acting under that document has what's called a fiduciary duty, which is the highest level of care someone can have. That means they always have to act in my best interest, and the law has repercussions if they don't. When I make something joint, those protections do not exist. So if they empty that account, I don't necessarily have any recourse. Too bad for me. The other thing to keep in mind is that there's a total loss of control when you make assets joint. Remember how we had talked about at the very front end that within the power of attorney document, the base starting point is they can't use my document to take my assets away from me and give them to other people. And they can only do it to the very limited extent I actually set out in the document. If I have joint assets, none of those restrictions are there. They can take my asset away. If they go through litigation, it's up for grabs to their creditors. And one of the real dangers is real estate in particular. Real estate in BC is publicly searchable. So anybody can search my name at the BC Land Title Office, and it will tell them every piece of real estate that my name is on. Now, let's say I put my son on there. And my son is one of those serial entrepreneurs. Some of them are going to go really well. Some of them are going to go not so well. One of the ones that goes a little less well ends up with creditors. And the creditors look up his name at the land title office. and the property comes up that's got both our names on it. They can now come after my property. The same kind of issue arises when you're dealing with family law breakdown. So if I put my
spouses
kids on there and they go through divorce, their soon-to-be ex-spouse is going to try and take a run at that. So this is a really important thing. And if anybody's interested, feel free to reach out. I have an entire article on this that I call the Fear of God article. Joint assets really should be treated with caution, and your power of attorney offers much more robust protections.
Yeah, I would like to say, Rose, we see a lot of clients come to us and request a joint account with their elderly parent or vice versa. And typically our general advice is to not do that. Instead, register the power of attorney on the account and get the same sort of result.
I think that's great advice. Everything, there are specific circumstances that vary. I mean, if I have a client who's terminal, they've got 6 weeks to live and we're doing this to bypass probate, our risks are pretty contained.
Right.
Yeah.
But if I'm 80, I could still have another 20 years in me. So don't give my stuff away.
Yeah, absolutely.
So let's look at how this applies at a practical level. One of the most important things to ensure that there's good financial management after you have an incapacity event is not just to have a good relationship with your doctor, but to make sure that your attorney has a good relationship with your doctor. You're probably thinking this sounds a little bit bananas because your power of attorney isn't about healthcare decisions. What's going to happen in practice is your power of attorney has to fund your healthcare decisions. So whoever you appoint to make your healthcare decisions under your representation agreement should be working very closely with your power of attorney to ensure that money flow is happening in a way that's going to meet all of your healthcare needs based on your particular financial situation and how long you're expected to have those needs. So my needs and how I need to budget are completely different if I'm already 95 than if I'm 60. And making sure healthcare decisions are made in a collaborative way that factors that in is very important. The other thing that's critical is do a complete inventory of your assets, of your people, everything you should and shouldn't have, and just as importantly, name this inventory clearly. Something that's buried in the back of your filing cabinet called transitions is not helpful in an emergency. Something that says I'm dead or I'm crazy, that's completely callous, but very useful. And when you're creating this, it's important to keep it current. So I may put one together, but if it's 10 years old, that doesn't really help me. If anybody wants it, I have an inventory checklist I'm happy to share. I generally recommend that you take a really hard look at it every couple years. And it's a great idea to do it around tax season because you're already having to pull up all your paperwork and make sure things are current. So that's the juicy bit. But I'm going to leave you with a bit of a fear factor because what kind of lawyer would I be if I didn't? When you select your attorney under a power of attorney, here are the practical things that are critical. Watch out for someone who's an American. And this has nothing to do with picking on anything about our friends to the south except their taxes. The IRS has exceptionally sticky fingers. And the way someone can be captured as an American is very nuanced. So at a 10,000 foot level, someone is American regardless of where they live. If they're a US citizen, so even if they live in Vancouver, if they're a US citizen, you have the tax problem. If they currently have a green card, if they used to have a green card and they didn't surrender it formally. So when a green card expires, your rights under the green card expire, but your tax obligations don't. And there's certain circumstances where if you have a parent who's born in the US, you can be American, even if you've never claimed citizenship or done anything there. But why do we care? If you happen to appoint someone who is one of these Americans as your attorney under a power of attorney, it triggers a disclosure requirement to the IRS called an FR. Under the FR, the person named as your attorney has to disclose to the IRS every year each account of yours that they can control by virtue of that power of attorney. So let's say I name Lorenzo as my attorney, and unbeknownst to me, Lorenzo's American. He now controls 6 different bank accounts. Every year, he has to file that FR and disclose that he controls those accounts. And where this gets so tricky and so problematic is that if he doesn't file that FR, the penalties start at $10,000 per account per year. So we could be looking at a minimum $60,000 penalty in a year. So appointing someone who's an American is really tricky. And I encourage all of you who have done your powers of attorney to double check the people you've appointed and make sure they're not what we call accidental Americans. The other thing to think about is just logistics and geography. Lots of organizations have regulatory requirements about knowing who your client is. So if I go to list a piece of real estate or open an investment account or hire a lawyer, they have an obligation to verify that you are who you say you are. You don't want them giving away your stuff if they're not really giving. A lot of them, however, have requirements that you have to do this in person. So if you named as your executor or your attorney somebody who's living in Spain or India, you can have a technical problem getting their identity verified. Some institutions will allow this to be verified through a virtual meeting or through a consulate or a lawyer wherever they're situated, but it is an institution by institution decision. So there's some inherent risk when you do that. And if you appoint someone who's geographically distant, I generally recommend that you appoint a backup who's either a professional trust company because they'll always be available, or someone who's more geographically convenient as a safety. Also, when selecting your attorney, make sure that they've got good records and bank statements. I miss the days when we had physical checkbooks and we had to balance things, because just ask your attorney, do you balance your checkbook every month? And if they did, you could go, oh, this is a pretty good choice. Nobody does that anymore. So it's really important that depending on how complicated your affairs are, they're going to be out for keeping the records and tracking all of that. And then the final point, we touched on this a little bit earlier, is the ability to collaborate with whomever you've named under your healthcare document as representative. Because he who controls the purse strings can have a direct impact on the resources deployed for your quality of life as part of your healthcare regime. So you can appoint different people, and there's absolutely nothing wrong with that, but really be mindful of the fact that they have to work together. So if you're in a blended family situation and you're thinking, oh, I'll appoint my spouse, they know exactly what I want, but you're going to appoint your kids as the power of attorney, you're going to have to work together. And that is the extent of the cool and interesting stuff about powers of attorney.